So, good day, ma'am. I am Arnold Peligrino, and I am here to discuss the Chapter 7, which entitled Laws Regulating Transportation's Establishments. So, in this chapter, the Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On the one hand, some of the best transportations and travel professionals are Filipinos. Seafarers, pilots, drivers, flight attendants, crews, cabin crew, aircraft mechanics, and there's a lot more. On the other hand, some of the worst recorded transportations, disasters, and accidents are in the Philippines. The transportation sector is thereof greatly affected by this concern. This chapter will deal with the different laws affecting the transportation sectors as they are integral in the study of tourism. So, in this chapter, our learning objectives are identify the laws affecting the transportation sectors, identify the rights of passengers of commercial transportations, and lastly, explain the relevance of these laws to the promotion of tourism in the country. Law on Common Carriers. Article 1732. Common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods, or both by land, water, or air, for compensations, offering their services to the public. So, a common carrier is defined as one holding itself out to the public engaged in the transportations of freight or passengers for hire. It is one who is the business of transporting goods or persons for hire as a public utility. A private carrier, in contrast, is not in the business of transporting public employment, but hires out deliver goods, not passenger. In particular cases, both in the Civil Code and Code of Commerce give clear-cut divisions between contract of carriage of cargo and contract of carriage of passengers, because the rights and defense in each kind of contracts are different from one another. So, nature of contract of carriage. So, a contract to transport passenger is quite different in kind and degree from any other contractual relations. And this is because of the relation which an air carrier sustains with the public. It invites people to avail the comforts and advantage it offers, not contract of carriage. Therefore, generate a relations attended with a public duty, neglect, or malfeasance of the carrier's employees natural could give ground for an actions for damages. So, responsibility of common carriers. Article 1733. A common carriers, from the nature of their business and for reason of public policies, are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them, according to all circumstances of each case. Article 1725. A common carrier is bound to carry the passenger's safety as far as human care and foresight can provide, using the utmost diligence of very courteous persons with due regard for all circumstances. Those for failure to use utmost diligence of a very cautious persons, the bus company should be held liable. Article 1756. In this case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently, unless they prove that they observed extraordinary diligence, as prescribed in Articles 1733 and 1755. Article 1757. The responsibility of common carriers for the safety of passengers as required in Articles 73 and 75 cannot be dispensed with or lessened by stipulations by the posting of notices by statement or on tickets or otherwise. So, liabilities of common carriers for the act of employees and strangers. So, Article 1759 rather, common carriers are liable for the death or injuries to passenger through the negligence or willful act of the former's employees. Although such employees may have acted beyond the scope of their authority or in violations of the others of the common carriers, this liability of the common carriers does not cease upon proof that they exercise the diligence of a good father of a family and the selections of supervision of their employees. Enforcement of liability of common carriers. So the liability of a common carriers can be enforced of the following causes of action. 1. In the case of death or injury caused to passenger, the victim may file a case of breach of contract of carriage or culpa contractual against the owner of the common carrier. 2. In case of death or injury caused to a stranger or pedestrian, the victim may file a criminal complaint against the driver of the common carrier for reckless imprudence resulting in homicide and damage to property. The victim may also file a civil suit against the common carrier and its driver on the ground of culpa acliana or quasi delect. Damages recoverable from common carrier. In action based on the culpa contractual or culpa acliana, the damages that are recoverable are as follows: actual damages, compensator damages, moral damages, exemplary damages, death indemnity, and attorney's fees. Nominal damages may be awarded in case moral or exemplary damages may not be awarded. Actual damages. So, kanang damage. Unrealized profits are recoverable as compensatory damages, which shall be fixed by determining the net yearly income of the injured or deceased passenger and multiplying the same by the number of years that has expected to live or lead a gainful existence as determined by morality tables of life insurance companies of the Philippines. So moral damages. So what is exemplary damages or corrective damages are awarded by way of example or correction of the public good or when the common carrier acted in wanton, reckless, and oppressive manner. So, award for death indemnity is in accordance with the current rulings of the court. Award for attorney's fees may be recovered when exemplary damages are awarded. In case moral damages cannot be awarded without proof of the carrier's bad faith, it will malice or wanton conduct. Nominal damages may be allowed under the circumstances. Nature of airlines bus shipping tickets. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline bus or shipping ticket is a contract of adhesions, considering that all the provisions thereof are prepared and drafted only by the carrier. The only participations left of the other party is affix his signature thereto. In such situations, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same. In this case, the carrier. So, regulation of the transportations businesses. So, the Department of Transportations and Communications or DOTC is the primary policy, planning, programming, regulating, and administrative entity of the executive branch of the government and the promotions, development, and regulation of the dependable and coordinate networks of transportations and communication system, as well as in the fast, safe, efficient, and reliable postal transportation, and communication services. It has the power, authority, and technical expertise to determine whether or not a specific transportations or communications project is necessary, viable, and beneficial to the people. Regulation of air transportation's businesses. Legislative Act Number 3909 passed by the Philippine Legislature on November 20, 1931 created an office under the Department of Commerce and Communication to handle aviation's matters, particularly the enforcement of rules and regulation governing commercial aviations as well as private flying. It was amended by Act 3996 to include licensing of airmen and aircraft inspections of aircraft concerning air traffic rules, schedules, and rates and reinforcement of aviation's law. Registrations of aircraft. Only an aircraft owned by or leased to a citizens or citizens of Philippines and which are not registered under the laws of any foreign country may be eligible for registrations. The certificate of registration is conclusive evidence of ownership, except in a proceeding where such ownership is in issue or when the aircraft is only under lease. Authority to operate. No franchise certificate or any other form authorizations awarded by Marina for the carriage of a cargo or passenger or boat in the domestic trade shall be granted except to domestic ship owners or operators. The term domestic ship owner or operator means a citizen of the Philippines or a commercial partnership wholly owned by Filipinos or a corporations, at least 60% of the capital of which is owned by Filipinos, which is duly authorized by the Maritime Industry Authority or Marina to engage in the business of domestic shipping. However, foreign vessel who may wish to engage in trade and commerce with Philippines territorial waters may be granted as a special permit by the Marina when no domestic vessels are available or suitable to provide the needed shipping service and where public interest warrants the same. By reason of the deregulations of the domestic shipping industry as mandated by Republic Act number 92/95 and to encourage investments in the domestic shipping industry, domestic ship operators are now authorized to establish their own shipping rates provided that effective competition is fostered and public interest is served. Accreditation of transportation vehicles by the Department of Tourism. This involves the minimum requirements for the operation, establish, and maintenance of transportation vehicles in order to be accredited by the Department of Tourism. Accreditation by the Department of Tourism, although not mandatory in nature, increase the marketability of transportation vehicle. Standard requirements for tourism land transport vehicles. To be registrable, every tourism transport must be found roadworthy upon inspections by the team from the Department of Tourism. In the case of bus or coaster, it shall not be done more than 10 years reckoned from the year of manufactured. For a tourist car, it shall not be more than 5 years reckoned from the year of manufactured, provided, however, that tourist luxury car shall be a maximum allowable age of 10 years. For this purpose, luxury car shall refer to passenger cars with engine displacement of not less than 2,190 cc and which are not locally assembled or manufactured. Every tourist transport shall be provided with a left-hand driver. It shall be properly equipped with adequate air conditioning units, and it shall be provided or installed with at least one portable fire extinguisher for the protection of its passenger. For tourist buses or coaster, a public address system shall be installed. Every tourist transportation unit shall be provided with a first aid kit and adequate supply of emergency medicines. It shall have clean and comfortable seat and shall have enough legroom and sufficient storage spaces. Lastly, every tourist transport operator shall provide an adequate garage and repair shop for the maintenance of its equipment, as well as parking space sufficient to accommodate all its registered units. In case of original registrations and or transfer of ownership of tourist transportation, the necessary clearance from the appropriate unit of the Philippine National Police shall be secured prior to registration. Seatbelt Law. The Seatbelt Law was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of vehicular accidents. In order to secure the safety of the passenger and drivers at all times, the mandatory enforcement of the use of seatbelt devices by the driver and front seat passengers of private and public motor vehicles shall be enforced. Law on Transportation of Animals. By virtue of Republic Act 84, 85, 65, also known as the Animal Welfare Act of 1998, it shall be duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases an adequate, clean, and sanitary facility for the safe conveyance and delivery thereof to their consign and the place of confinement. These animals shall be provided sufficient food, water, while in transit for more than 12 hours or whenever necessary. No public utility shall transport any such animals without a written permit from the Director of Bureau of Animal Industry or his or her authorization representative. Any form of cruelty shall be penalized even if transported has obtained a permit from the Bureau of Animal Industry. Cruelty in the transporting includes overcrowding, placing animals in a trunks or other than food trunks of the vehicles. Public Service Law. Public service includes every person who may own, operate, manage, or control in the Philippines for hire compensations with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes. Any common carrier, railroad, or street railway, tractions, railway, subway, motor vehicles, steamboat or steam line, ferries, and watercraft shipyard. Unless otherwise exempt, no public service shall operate without having been issued a certificate of public convenience or a certificate of public convenience and necessity. And that's all. Thank you.